Good morning, everyone. Welcome to our 26th Annual Elder Law Forum. We're very thrilled that you could join us today. We have 2 days of phenomenal programming and speakers, and I'm excited about it. It's a critical time, critical juncture. We have a lot of things going on in federal government, state government. We're going to cover all of those issues, but I just want to take a walk back and look at where we've come. This is our 26th year. And the foundation of much of our discussion is what happened in 1965. As we all know, Lyndon Johnson's Great Society program, which brought us Medicare and Medicaid. And that history is very relevant to all of our conversations as it pertains to aging, healthcare, and long-term care. And Medicare was the program, as Johnson said in his preamble, that will make it so that seniors in America will never have to worry about health care again. Well, that was then, this is now. And now we have a Medicare program that is still vital to the health of our nation's seniors, but we have an entire topic that has been carved out called long-term care. And long-term care has unfortunately flipped over to the Medicaid program. And so we have to deal with Medicaid. And one of our speakers on the 4th of June, Gail Halabinka, her mantra throughout this, and she's been in this field for over 35 years, is, but for the need for long-term care, seniors would never need any governmental assistance. So today, we're going to focus on Medicaid and the changes that are looming in New York State in the Medicaid program. We have to look again at New York's evolution. I was fortunate to have been tapped to be on the governor's task force on long-term care reform in 1996. And that kind of formed a lot of the basis for this Elder Law Forum, because I was able to get an education on the systems in New York. And the systems 26 years ago were broken, and the systems today continue to be broken. We issued a report from that task force with a number of recommendations, very few of which were followed. And today we have all of the changing demographics, which were predictable, but have caught us apparently by surprise. And that is the baby boomers retiring, hitting 65 at the rate of 10,000 per day, coming on the Medicare rolls, the life expectancies expanding, and the inability to keep pace in our aging care system with the people living into their 80s, 90s, and 100s, and the needs, while they develop chronic conditions, to provide them with not only health care and acute care, but long-term care, the services and supports that they need to live independently and to receive the care they need through the aging process. The cost of that care has skyrocketed. We have a vast audience today. Thank you all for joining us from upstate, downstate, western part of the state, pretty much all of New York State. But the cost of care, just in our capital region, right now we're looking at nursing home costs of $16,000 per month, and private pay home care 24 hours a day, 8-hour shifts paying a private agency of about $250,000 per year. And we have clients paying that privately to get the top level care that they can find. So the financing system is broken. I don't think anybody can question that. And now we have to look at what's happening. So we have in Washington, and we're going to hear about this on June 4th, we have a $400 billion piece of the infrastructure bill that is designed to expand home and community-based services. That is the real push. We're going to hear from Senator Kirsten Gillibrand, who is on the Senate Aging Committee. That is the focus in Washington right now, and also David Goldfarb, the lobbyist for the National Academy of Elder Law Attorneys in Washington. He's going to be with us on June 4th. The focus is on home and community-based services. And now we have New York, which is curtailing community-based services and making it harder to get. So our panel today is going to be focusing on New York State's Medicaid program, what is today and what's going to be coming when the looming changes occur. And so it's vital to all of us in this field to know, both at the macro level, what's happening, Washington, Albany, across the country and across the world, because aging is not a unique situation in the United States, but also what's happening in the home of, in this case, Betty, who we're going to do a case study for in the second half of today's presentation. What is Betty's best course? What are her needs? How can she meet those needs? And how can her family, the caregivers, work within a system to find the care that she needs? Labor shortages are exacerbating this problem. You're going to hear Al Cardillo talk about that this morning. And budget deficits continue to plague us. And when Medicaid has a problem, last year, we need to cut $2.5 billion from Medicaid. Go make it better. And that's how we're processing this. There is a lack of long-term thinking, and government is not good at long-term thinking. There's a lack of innovation, and the payment for care has not yet been resolved. We have a long-term care insurance market that has struggled, and we're going to hear from two insurance experts, two of the leading carriers in the country, Nationwide and Mutual of Omaha, again on June 4th. But today, I want to thank our sponsors, because this conference, we hope to be live again next year, and we're thinking of a hybrid so we can do it live and by video feed. So our sponsors each year help us put this together so that you can attend free of charge. And our speakers donate their time, and it's a tremendous amount of time to prepare for this forum. And I want to thank NYSARC, Quantic Bank, who have been steady, very good sponsors for our Elder Law Forum, Nasentia Health, Northeast Association of the Blind, AARP, the Center for Special Needs, NYSILC, Everhome Care Advisors, and Viva Links. These are our sponsors that make it possible for us to present this to you and to do it on a cost-free basis. So thank you all so much for supporting the Elder Law Forum year over year. Just a little update on Pierro, Connor, and Strauss. We have been doing this forum for 26 years. We've grown over that time. We now have a slate of attorneys that you see there in front of you, 11, and we now have 12. We got to get the other picture up there. Victor Oberding just joined the firm, so we're at a dozen. Our New York City office has been expanding. We have 5 attorneys in New York City. We have 7 attorneys now in Albany, and we're focused on estate planning, but elder law special needs planning has really been the core of our firm, and thrilled to have several of the people that you see up there as part of the program over the next 2 sessions, today and again on June 4th. So with that, the agenda today, we're going to talk about Medicaid update. And for that, I'll introduce Valerie Bogart in a moment. And we are also going to,
There you go.
all right. We're also going to talk about the future of home care. Not sure what's going on with my slides. And then anatomy of a home care case will be this afternoon. So with that, late morning. Next session, again, June 4th, Senator Gillibrand will be giving an address, but we have a tremendous slate of speakers, including Assemblyman John McDonald, Senator Susan Serino, Greg Olson from the Department of State Office for Aging, Adam Herbst from the Department of Health. We have Beth Finkel, the statewide director of AARP, Jim Klein from the leading age nursing home providers. We have the insurance specialists, and myself and Gail Halabinka talking about some financing ideas that have been around for a while, but maybe ripe again for discussion. So with that, I would like to introduce our first speaker of the day. That is Valerie Bogart. And Valerie has been generous with her time for us. She's spoken to our group for several years now, and she's the director of the Evelyn Frank Legal Resources Program at the New York Legal Assistance Group, NYLAG. And NYLAG, I can tell you, is one of the best resources as an elder law practitioner that we have. They follow the law and do the analysis that as a private practitioner, you just wouldn't have the ability to do. And we love having Valerie come each year and give us the update, as she does for so many groups and across the state and in fact, across the country. So with that, to bring us up to date on New York's current Medicaid changes, I bring you Valerie Bogart. Valerie.
Okay, thank you, Lou. Hello, everyone. I know there's lots of people out there, lots of friends. Special shout out to Office of the Aging of the state, HICAP, Brenda Lemire, and lots of other friends. So there's lots of changes. We're going to be talking about, I am from NYLAG. We're a nonprofit in New York City. We do a lot of education and policy advocacy in addition to direct representation. So first, we're going to talk about some past cuts that were only implemented recently. Then we're going to talk about the look back, which I know everybody wants to hear about, and the home care changes. There are things in here we're going to get to the COVID easements. You have information in here about how applying for and keeping Medicaid is easier because there's a public health emergency. So take a look at those slides at the end of the presentation. There's also a information sheet posted on the Pierro website, and also it's in the links of just a lot of links that go into a lot more detail on all of these topics. So just in case you've missed this, back in 2017, the law changed, but it was only implemented just a few months ago, last December, that when you join an MLTC plan, if you join an MLTC altogether after December 2020, or you change plans, you have a 90-day grace period to change plans for any reason, and then you can only change plans for good cause for the next 9 months. And that's called lock-in. And that's only for the partial cap MLTCs, what we consider the regular MLTC plans. It's not true for PACE or Medicaid Advantage Plus. Just advocacy tip, if your client, sometimes people want to change plans because Plan A is not giving them enough hours, or because Plan A no longer contracts with that home care agency. There's been a lot of change in the contracting. Some of it mandated by the state because the plans had to cut down how many home care agencies they contract with. So they want to keep their aid and they want to switch plans. Beware that the new plan, that's considered a voluntary change. That new plan does not have to give the client the same number of hours they received from Plan A. So Plan B can reduce hours. It's not considered in the state's eyes a reduction of services. So you don't have rights that you have normally if you change plans involuntarily, like if your plan closes or you had immediate need services and then were required to transfer to MLTC. Those are involuntary changes. And in those situations, you have what we call continuity of care rights or transition rights, where Plan B is required to continue the same plan of care. So when you're advising clients on that, they have to think twice about it, especially if they have high hours. They are at risk of losing those hours. If they have the right to transition rights, then there are strong rights which you want to become familiar with, that the plan can only reduce hours for cause. Another change that just went into effect last August is called the long-term nursing home stay exemption. So 5 years ago, there was a big rollout of people who stayed in nursing homes for more than 3 months were required to join an MLTC plan. Or if someone was in MLTC and they went into a nursing home, they didn't disenroll from the plan. They stayed in the plan, even if they were now permanently placed in the nursing home. Now they changed their mind and they said, nah, we don't like that anymore. Now we're going to, after 3 months in a nursing home, if you've been approved for long-term care Medicaid, which means the 5-year look back has been done for nursing home care, you get a notice from New York Medicaid Choice that says, we think you're long-term. If you disagree, if you plan to go home, you can request a hearing or you can call Medicaid Choice. Otherwise, we are disenrolling you from the MLTC plan. Now, already there have been 20,000 people in plans, nearly 10% of the entire MLTC population have been moved out of plans, and they're in regular fee-for-service Medicaid to pay for their nursing home care. Now, they get this notice. We understand very few fair hearings have been requested, like I think under 10 out of the 20,000 people. Now, the state did ask the plans and nursing homes to identify. They gave them the list of these 20,000 people, and they said, which of these people have active discharge plans? Because we're going to take them out of the list. They will not be disenrolled. They'll stay in the plan so that when they're ready for discharge, they can go home. Advocates see a lot of problems with this because the notices were sent to the nursing home residents in the nursing homes. And this is continuing every month, or every few months, this will be continuing. So we know that visitation was closed all of last year and until very, very recently. So that nursing home resident, did they have the wherewithal to read that notice and request a fair hearing? Did the nursing home help them with that? We know nursing homes have been pretty busy with COVID with other things. So we're not confident that people got these notices and were able to really process them. A family member didn't get the notice also unless they're listed as authorized rep on the Medicaid application. So we're recommending that people, if they want to be sure to be informed if their loved one or their client is receiving this notice, to make sure they stay in their plan, you have to make sure you're listed as authorized representative on the Medicaid case at the DSS, which sort of doesn't make sense because that doesn't seem to be connected to MLTC, but that's what the state's using as their list. So with problems, call ICANN or the MLTC complaint line. So now we're going into the more recent changes enacted last year, starting in January 1st of next year. If this is approved by the federal government, which it has not yet been, but the state will be starting a look back for community-based long-term care, and you'll see this abbreviation throughout. And that's all home care, MLTC, and assisted living program. So just a refresher for we're all on the same playing field. A look back means that when you apply for Medicaid, you have to include financial records, not only of the current month, but records back to a certain date. And in this case, that date will be October 1st, 2020. And so at first, on January 1st, 2022, the look back will be 14 months, because that's how many months it is back to October 1st, 2020. Then they'll keep adding a month every month until the look back is 30 months or 2.5 years. Again, that's if CMS approves it. Now that's a little up in the air because under federal law, it says the look back is 5 years if the state opts for it for community-based care. So we don't know if CMS will approve one for shorter. What is this? What is being looked at in those financial records if there was a transfer? And a transfer is a gift or any exchange of assets for less than fair market value. So if you sell your house to your daughter for $1, that's not fair market value. So that would be a transfer. There are certain exemptions that apply, which we will not be going into. There's a slide on it, but the exceptions are complicated, and those are the same ones that apply to nursing home care. They're using the same penalty rate as for nursing home care. There's a lot of questions that come up about people who already have Medicaid and they did transfer assets after October 1st, and they're afraid that at the renewal next year, they'll be subject to the look back. They will not be. The state has said this was only for new applicants. And I'll describe this one other group, people who request increased coverage. So just as a refresher, we have a look back for nursing home care, it's 5 years. And that's because federal law mandates that. Every state has to do that look back for 5 years and impose a transfer penalty for nursing home care. But it's optional for home care, and New York never did it, but now they decided to do it in 2020, and that's why it's going into effect. Now, a lot of the details on this have not been set yet. The only thing we know is what they've proposed to CMS, and that's where the link at the bottom of the slide gives you some detail, but it's not approved yet. There are no regulations, so a lot of details are still going to be fleshed out. As I said, it covers all home care, personal care, CDPAP, private duty nursing, assisted living program, and even CHA services, Certified Home Health Agency services, which we have a big question about because usually those are short-term, out of the hospital or out of a nursing home after rehab, and we strongly oppose doing a look back on those services because when those are needed immediately. So that's, again, up in the air. It will not apply to the waivers like nursing home transition and diversion waiver, the TBI waiver, and the OPWDD waiver. Question on that is how, if you're only applying for Medicaid and you're not in those waivers yet, how will your DSS know that you shouldn't be subject to the look back because you're seeking those waivers? These are things that still have to be worked out. It will not apply to mainstream managed care, even though those plans, those are for people without Medicare. Those of us working with the elderly don't deal a lot with those plans, but 5 million New Yorkers are in those plans. And if you're in that plan, those plans give all of these services on this slide, but it will not apply to those. All right, you can still get those services on the top of the slide if you're in a mainstream plan. And it only applies to long-term care, not acute primary care, hospital care. So as I said, it will only apply to people who are newly applying after next January 1st. So not to renewals after January 1st. The state has made that clear. There are some people who applied for Medicaid before January 1st who it might apply to. And those are people who applied for Medicaid without long-term care coverage. And so on the SUP A, if you didn't check that you want community-based long-term care coverage, or in New York City before, you didn't need to submit a supplement A. I'm referring to the supplement to the Medicaid application, that in New York City was only required for people seeking community-based long-term care. They recently changed it, so now supplement A is required for everyone. But if someone applied without the supplement A, and so that means they weren't seeking community-based long-term care, if they now need community-based long-term care after the 1st of next year, they will be subject to the look back. So that's something you might want to check with clients. The state's made it clear that as long as that application has been submitted with the supplement A, checking off community-based long-term care before January 1st, you will not be subject to the look back. It doesn't matter if you're enrolled yet in an MLTC plan, if your service is started. This is what the state has said. So that was a relief. Now, because of the pandemic, one of the COVID easements is that any applicant can attest to the amount of their resources and not verify them. So normally, you're only eligible for community-based long-term care if you verify your assets. Because of COVID, you don't have to. So we think that means that as long as you have submitted a Medicaid application with SUP A Even if you've done attestation because of COVID, if you've checked off the box on the supplement A for community-based long-term care, you should be good. You should not be subject to the look back after January 1st. As I said, the city, they're finally using the statewide supplement A. So everyone upstate, you don't have to listen to this because you've always used Form 5178A, but the city was using a different form. Now we all use the same form. And on this one, you have to note that the spouse has to sign it, even if you're doing spousal refusal or if the spouse is not applying. That's why the city is changing to this form. Because for the look back, the spouse's assets have to be verified too. This is the phase-in, which I've already described. This is a big change. We're used to saying if you're doing spousal refusal, that many people don't verify or even report the spouse's assets. Now we know that with spousal refusal, the spouse is still liable and can be sued by the county or HRA, and they can be asked to repay the costs based on their ability, their assets and income. But they didn't have to verify assets for eligibility. Now, because of the look back, they do. So this is a very big change that I want everyone to get their heads around. And the reason is, let's look at this example, and this will illustrate why. So spouse, Randy, transferred $50,000 during the look back period. Randy still has $200,000. Randy can still do a spousal refusal. So that $200,000 will not count for Pat's eligibility. Now that is subject to a claim for spousal support, which of course Randy has to be advised that he can be sued by the county for that. But Pat can't be denied Medicaid because Randy has the $200,000 if Randy's done a spousal refusal. But the $50,000 transfer counts against Pat. A transfer by a spouse triggers a transfer penalty for the applying spouse. So that's why the spouse's assets have to be shown for the look back. So none of this, sorry, doing spousal refusal, you don't have to. Yes, you have to, they have to sign the supplement A, and they have to show their assets. The length of the transfer penalty, you total up all the transfers of the applicant and the spouse for the transfer period. The look back period divided by the local nursing home rate, which this is the rate for New York City. Other regions are at the link, and you get 3 months for a $39,000 transfer, just rounding there. So that's the same as for nursing homes. So that's good. They're using the same rate. The same exceptions apply, which I'm not going into, as for nursing home. But they're on the slide. There is some issues about the home. We're waiting for clarification from the state. The rules on the home for nursing home care are very limited. The transfer of the home is allowed to a spouse for a disabled child, or to what's called a caregiver child, or siblings with an equity interest. The state's saying those same rules apply and no other transfers are allowed. Advocates and the State Bar Association said, well, wait a minute. It's different. This is someone living in the home. They're allowed to have the home as an asset if the equity is under $906,000. That's the equity limit. Or if a spouse, a minor, or a disabled child live there. They're living there, as opposed to in a nursing home. The whole idea is that you're considered to be moving into the nursing home. It's not an exempt asset because you're no longer living there. That's if it's a permanent placement. So it should be different. The state's saying, no, it's the same. And in fact, they're even saying that the caregiver child exception won't apply, because that exception applies only if a child lived with the client, the applicant, for 2 years before they became an institutionalized person. Well, they're not institutionalized. That's the whole point. They're living at home. So that would make no sense. We've submitted comments. The State Bar has submitted comments on this. You could look at our comments. We think that's wrong. We hope CMS says that's wrong. We have to wait and see. There's also a hardship exception. So let's say, Barbara did transfer $50,000 to her daughter, who spent it on, because she was laid off during COVID and she had no money, and that's how her family lived. And there is an exception that says to deny Barbara medical care would cause her an undue hardship, would deprive her of medical care. Home care is medical care that would endanger her life. But how do they define that? She has to make best efforts to get return of the assets. And one of the criteria is that her income and assets have to be below the Medicaid limits. Now, that basically means that anyone with a spend down or using a pooled trust would be not able to get the hardship exception. So we think that definition has to be changed for community care. The definition in the nursing home doesn't work in community care. Very concerned about delays on the look back. Obviously, this is going to be a huge burden on the local Medicaid agencies. Right now, they only have to review current eligibility. We have to review 30 months of bank records, investment account records, IRA records. Some of this will be available to them electronically. That will help limit paperwork. So for example, for bank accounts, the client shouldn't have to get their 30 months of bank records because the district has them electronically. But there's lots of other assets. There's life insurance, cash value, there's the home, there's investment accounts, and none of that's available through that asset verification system. So there's going to be long delays. They're not going to be able to comply with the requirements now. And think of immediate need applications. They're supposed to be decided in 12 days with home care approved in 12 days. There's no way. Big question, can income still be placed in a pooled trust? This is up in the air. We think that the state will say that pooled trusts can still be allowed because we think they pretty much have to under CMS Medicaid guidance that's here, but we think there might be some issues on whether they require that every deposit be spent immediately in the same month it's deposited. So again, we're waiting for the state's policy on that. You have to just stay tuned. The state has come out and said that they'll use basically the same rule for when the penalty begins as for nursing homes. That even though the law says the penalty would only start running when the client is receiving services, which wouldn't make sense in the home, they're saying that they'll use CMS policy that applies to certain waivers to say it's when they would be receiving home care if they were approved. So when they would be eligible. So in other words, it could be when they apply. So that it would run the same as for a nursing home. So let's say that example I gave, that was $40,000 transfer, 3-month penalty period. The way I think it should work is that when you apply, let's say it takes 3 months to get this whole thing done. By the time the application is approved, as long as you've shown, I think they'll require a new doctor's form to be submitted with the application to show client is eligible for home care, that at the end of those 3 months, a 3-month penalty should have run. And now the client can enroll in an MLTC plan. Now, of course, if it was a $200,000 transfer, that's different. It won't run. But a $40,000 transfer should run. That's what I think. Again, we don't have any final guidance on it. All right. The next big change is they passed also in 2020. Now you'll need a minimum number of ADLs to qualify, and there's a whole new procedure for applying for home care. So under current law, we all know, I think, what activities of daily living are. Quick list here: activity days of living, bathing, personal hygiene, dressing, walking, transferring, toilet use. Right now, if on the conflict-free assessment, or if you're applying at your local DSS or managed care plan, they find you need just one ADL, you qualify for home care. You have to need assistance with one ADL. That's it. Under the new rule, you must meet this criteria. Most people will need 3 ADLs. They'll need limited assistance with physical maneuvering with 3 ADLs. The exception is for people who have dementia or Alzheimer's diagnosis, and they can have only 2 ADLs, for which they must need at least supervision. This will only apply to people who are not yet receiving home care by the time they implement this. When will this be implemented? I don't know. It's already later than the statute said. It could be sometime this year. It could be next year. So current recipients will be grandfathered in. Now let's drill down a little bit. So IADLs do not count, and note that they don't include transfer other than for toilet use. They only count transfer for toilet use. But we're concerned that the need for assistance with the housekeeping services does not count at all for your eligibility. Now, one of the big concerns here is that before, let's say the conflict-free assessment said, you know, you don't need any ADL assistance. Go apply to your local Department of Social Services for housekeeping services. And the law gave up to 8 hours a week for housekeeping services, which was at least something. It's only 8 hours a week, but it's something for someone who could take care of their personal needs, but they couldn't lift a laundry bag or wield a vacuum or go out shopping. So this is going to be eliminated. This service is going to be eliminated entirely. And so people over 60 can get ISEP services through the County Office of the Aging. Now, I saw a lot of people are here from County Offices of the Aging. Isn't there a big waiting list for ISEP services? I think so, in most counties. So there's not a lot of capacity for more people on top of the baby boom, as Lou mentioned before. So, and how about people under 60? People under 60 have disabilities too, and they're not eligible for ISEP. So this is a big concern. Now let's drill down. When they say that you need limited assistance, this is what they're talking about. This is a snapshot of the UAS, the Uniform Assessment System instructions that define what these levels of assistance are. And limited assistance is defined as guided maneuvering of limbs, physical guidance without taking weight. So that's what you need 3 ADLs with. We still have questions on this. Does that include contact guarding, which it's sort of like hovering, where the aide is not really hands-on, but walking close by? Or is that considered just supervision, oversight, and cueing? Supervision, oversight, and cueing only counts if you have dementia or Alzheimer's. Otherwise, it doesn't count to meet the minimum ADL criteria. Now, what if you need supervision and cueing, but not because of dementia, but because you have a traumatic brain injury or a developmental disability, or you're blind? For those, supervision doesn't count. The need for supervision doesn't count. You must need that physical assistance with an ADL. We think that this is just simply illegal. It's discrimination based on diagnosis. And the state can't pick and choose which diagnoses qualify for a service. Now, I've used the word supervision a number of times, and I imagine some of you are wondering, wait a minute, I thought Medicaid, and we're always told that New York doesn't cover supervision or safety monitoring. So just a note on that. It's true that a 20-year-old court decision said that New York Medicaid doesn't have to pay for standalone supervision. That's for someone who doesn't need any help with ADLs. But when the supervision is the type of assistance that the client will get with an ADL, then yes, it is covered. So the work for us as advocates is to make sure that we always connect the supervision with an ADL. So it's cueing and prompting for safe ambulation, or for toileting, prompting the person to take down your pants before you go to the bathroom, how to clean yourself, where the bathroom is. All of that is covered by Medicaid because it is assistance, verbal cueing with an ADL. So that's something a trick you want to use. This policy, there's a link to it in that fact sheet that's posted on the site, 1607, very, very important. That's a Bible for anyone who does home care advocacy. All right, just 2 minutes.
Valerie,
yes?
you have just about 5-6 minutes left.
Great, okay, we're good. The new assessment system. Again, we don't know when this is starting. So there will still be a conflict-free assessment from MLTC. Excuse me, that will still be done by New York Medicaid Choice. Excuse me. The changes that now, that assessment will now swap in for the MLT's assessment. The MLTC will no longer do a separate nursing assessment. They will use the conflict-free assessment as their nursing assessment, and that is this independent assessment. So, and that will now not only be used, the New York Medicaid Choice will also do it as the nursing assessment every year at the reassessment. The plans will no longer have their own nurses do these nursing assessments. The big change is that after the nurse does that from New York Medicaid Choice, a doctor or a physician's assistant or nurse practitioner will also conduct what they call an independent practitioner panel assessment. And that's going to be done on every assessment, every year, every reassessment. So that's an entirely new assessment. And that goes back to the plan or back to your DSS. They use those two assessments to authorize services. This is a typo here. Change that to less than. if the needs are less than 12 hours a day. Sorry about that. If the plan or the DSS says, oh boy, these assessments show this client needs more than 12 hours a day, and these assessments can all be done by telehealth, they say if the client agrees, we have big concerns about that, then DSS or the plan refers it for this new high need review called the IRP, the Independent Review Panel, by guess who? New York Medicaid Choice. And that panel will decide whether this proposed plan of care is appropriate to maintain health and safety in the home. Now, whenever you talk about safety for people with disabilities, it raises big red alarm bells about Olmstead and the ADA, because there's a lot of pretext and assumptions that that can be projected on people to say they're not safe. And this is something I've seen it for 30 years as a home care advocate. That, oh, it wouldn't be, it's not safe for you, you have to be in a nursing home. And usually the answer to that is, actually the care is safe if you give enough hours. It's a pretext for denying high hours of care. Sure, the person isn't safe with 4 hours a day if they need to be turned and positioned, if they're not safe to walk, if they're up all night because of dementia and they walk at any time at night. Of course, they're not safe, but they're safe with 24-hour care. So it can be a pretext. We have to really watch for this. And of course, we're concerned about, this is the state's graphic, it's just the same thing I just said. We're concerned about delays from all of this. These are all new assessments. It's already slow getting home care. When you request an increase from a plan, the plan's supposed to respond within 14 days, or even 3 days if the request is expedited. How is they going to respond in 14 days, let alone 3 days, if all of those assessments have to be done? The plan has to refer the case to Maximus to do that new nurses assessment, to do that new physician's assessment. And if it's a 24-hour care, to do that new high need review and get it all done in 14 days, it's just not going to be possible. So I will be around to answer questions. We have slides here on COVID protections that you can look at on your own later. Okay, back to you.
All right. Does everybody else feel like they're trying to drink from a fire hose? There is just so much complexity, and it's kind of those Donald Rumsfeld 3 levels of knowledge. We know what we know what we don't know, but we don't know what we don't know. And it's so complex. How does it impact individuals? Well, fortunately, we're going to break it down and be granular about it and look at it step by step through the application process in a case study involving Betty. And that's going to be the second half of this morning's presentation. And as you can tell, this is not legal work with the Medicaid application when you're dealing with, and we should have given Valerie a warning that this is going to be graphic content. Someone's pants coming down and talking about how they go to the bathroom. Is that in a legislator's mind when they're passing Medicaid laws? Is that something that they're thinking about? It's 30,000 feet versus in the bathroom, in the bedroom, in the kitchen. How does this impact people and their everyday lives? So the panel this afternoon will be talking about that. 2 weeks from now, we have 2 legislators on to talk about the legislative side of this. Valerie, do you want to comment? You're muted. There you
No, I don't need to comment right now.
Okay.
Okay.
And then what happens if Betty doesn't get the care that she needs, if she doesn't get the hours she needs? Valerie and a panel are going to talk about fair hearings and appeals under the old rules and the new rules. And that, again, is part of the second half. Many of you are posting questions. Be sure if you're going to post a question to post it to the Q&A. And we're not going to be able to get to all of your questions this morning. live. We will take some questions after our next speaker. But what we're going to do is we're going to compile a compendium of every question asked, make sure it gets an appropriate answer. We're going to put that compendium together, and we're going to send the entire list of Q&A out to every attendee. I find that most times I'm not the smartest person in the room, and other people ask really, really good questions, and I benefit from their answers. So we'll make sure that everyone gets the answers from all of the different people that post questions, and again, post them to the Q&A.